Members, this is the appointed time and we have a quorum, so I call this meeting to order. This is the both Committee on Mainland Judgments in Civil and Commercial Matters Reciprocal Enforcement Bill, and this is the third meeting. Item 1 at meeting with the administration. Let me first invite the administration to come in. With us today we have Deputy Solicitor General, Policy Affairs, Ms. Jenny Fong, Ms. Peggy Aoyang, Senior Assistant Solicitor General, and Ms. Annie Lee, Senior Government Counsel, Ms. Christina King, Government Counsel, and also Ms. Selina Lau, Senior Government Counsel, and Ms. Wanda Lam, Government Counsel, all from the Department of Justice. Now, would members please note that the papers relevant to our agenda are as set out for members' reference. Based on our previous deliberations, the Bills Committee already posted an advertisement on Lecho's website inviting members of the public to submit written submissions. The deadline was 5 p.m. the 31st of May 2022, and the Secretariat received altogether 2 submissions, and these submissions were forwarded to members by email on the 23rd of May and the 1st of June, respectively. The Secretariat also invited the administration to give a response. And as I said, the administration already provided a written response to the written submission provided by Guangdong, Hong Kong, Macau, Greater Bay Area Socialist Research Institute. And the response will be forwarded to members along with the submissions. So without further ado, we will now continue with clause-by-clause scrutiny. At the end of the last meeting, we completed clause 1 of the bill, and we will start with clause 2 today. So would members please refer to this blue bill, which we used last time, as well as a marked up copy prepared by the Electrical Legal Research Division. And we will be reading both the Chinese and English text of the bill at the same time. I will invite the administration to start clause 2. Clause 2 is the interpretation clause. The clause sets out the definitions for certain terms to make the bill more accessible. Yes, please speak into the mic. Speak louder, please. The second clause is interpretation. We set out the definition of certain terms to facilitate users and also to clarify the drafting of the bill. I'm not going to go through each and every definition, but I welcome questions from members and the legal advisor. Members, if you have questions, please press the request to speak button as we go along. So for clause 2, the interpretation, any questions? Legal advisor, anything to supplement? Thank you, Chairman. Members may note that there is a definition. Mainland judgment means a judgment, ruling, conciliatory statement, or order of payment given or made by the Court of the Mainland, but does not include a ruling given in respect of an interim measure. So would the administration please explain to members what an interim measure means, and also under what circumstances would a court in the Mainland make such a ruling in respect of an interim measure? Thank you. Indeed, in Mainland judgment's definition, we do not include a ruling of an interim nature. Under the Mainland law, before the start of any legal proceeding or during the legal proceeding, a court in the Mainland may give an order of an interim nature. And in fact, we can refer to the Civil Procedure Code of the Mainland, which provides for the relevant principles which are similar to Hong Kong. One type is for keeping evidence, and that is to prevent evidence being destroyed by one of the parties. So it's for keeping evidence. The other is for maintaining assets, that is to prevent one of the litigants from removing the assets or realizing the assets. And that is why a court in the mainland can give an order in this regard in order to keep evidence and maintain assets. The ruling as such is transient in nature, and it is not included in the scope of the bill. They'll be excluded. Two members would like to speak. Ms. Carmen Can, 4 minutes. Thank you, Chairman. My question relates to the word effective in Clause 2 interpretation. I understand that in discussing policy issues, the Department of Justice referred to an effective judgment. So we've now come to Clause 2 and the word effective. And then in relation to a mainland judgment, see Section 8. And then in relation to a Hong Kong judgment, see Section 9. At the same time, I note the Lead Law Society's submission dated the 31st of May, and that we use this term effective judgment in a bill. As for other reciprocal related bills, such as CAP 579 and 395, the concept is final and conclusive. So it's a final judgment. So in light of the issue raised by the Law Society of Hong Kong, would the administration please explain this term under interpretation to us, whether this bill relies on the concept of effective judgment, and what is the consideration? Why is it different from the other two pieces of legislation, CAP 319 and CAP 597? Ms. Aoyang. The member's question relates to effective judgment, and I'm sorry, please speak into the mic. Thank you. Is it coming through? Effective judgment refers to Clause 4 of the agreement signed in 2019, and indeed, we're using the concept of effective judgment stemming from the agreement signed. The purpose of adopting this term is that when we refer to the original principle, once a judgment has been made in one jurisdiction, if a litigant asks for enforcement of this judgment in another jurisdiction, the principle is that in the original jurisdiction where the judgment has been handed down, it should be effective in the first place. It must not be a judgment that is not valid in the original seat of litigation. So that is what we should have as a prerequisite for enforcing that judgment in that jurisdiction. So we refer to the other relevant agreements, such as the Hague Convention, which also adopts the same principle. The bill reflects the agreement signed in 2019 and therefore adopts the same practice. As far as the definition is concerned, for effective judgment in the mainland, it means that it has gone through the first or second instance, and that is a judgment made under the relevant supervisory procedures. So, in other words, an effective judgment in the mainland means that the appeal period must have been lapsed, and of course, if another litigant lodges an appeal, then the proceedings of an appeal would be initiated, and that's the judgment of a second instance pending. So for an effective judgment, the appeal period must have lapsed, and that according to this principle, the judgment should be final and conclusive. In the mainland, there is this procedure, and under the procedure, that is trial supervision procedures, a case can be retrialed. For any judgment handed down under the trial supervision procedures, the judgment is also one of an effective judgment. And it is true that the definition of an effective mainland judgment can be found in Section 8. For Hong Kong's situation, I think we are more familiar. That is a judgment that is declared or handed down by a court in Hong Kong and is valid. Now, we understand that there are differences in the two jurisdictions, and it is also reflected in this provision. For a judgment handed down in Hong Kong, it is effective even if it is enforceable in Hong Kong unless a litigant files for stay of proceeding. That is, I've lodged an appeal and I am asking the court to grant another order for stay of proceeding meanwhile. And if somebody files such an application and it is approved, then the Hong Kong judgment is no longer enforceable according to the court in Hong Kong. Otherwise, even for a judgment handed down in the first instance, it will be effective. So there is a difference between the two mechanisms. In the mainland, according to their laws, only judgments handed down in the second instance or where the appeal period has lapsed would a judgment be effective. Can I follow up on this reply? Thank you. I thank the Department of Justice for their reply. I think you're trying to explain in an easy-to-understand way that by using the word effective, you are reflecting the agreement signed in 2019. And for a mainland judgment, in order for it to be effective, they have their own requirements. And that is why you're not using the terms final and conclusive as you have used in CAP 319 and CAP 597. For reciprocal enforcement arrangements, I want to get an understanding of the terms used. And I understand the differences here. And this is also the crux of the Law Society's question. On this occasion, we're using the term effective judgment. Now, is it really consistent with final and conclusive? Just for the moment, set aside the concept final and conclusive. In Section 8, you have effective mainland judgment, and in Section 8B1, it is a mainland judgment given by the Supreme People's Court. Now, if it's a judgment given by the SPC, whether it's final and conclusive or not is of no relevance. It is still effective. Or Roman number 2, it is a mainland judgment of the second instance given by a high people's court or an intermediate people's court. So regardless of the level of court, if it is of the second instance, it is effective. The third scenario, if it is of the first instance, given by whatever level of court, it can still be effective as long as nobody files an appeal within the statutory time limit, or according to the law of the mainland, the judgment is not subject to appeal. So you've set out the different scenarios to explain what is meant by effective mainland judgment instead of adopting this term final and conclusive. Am I right? If I'm right, then in the future you should amend CAP 597 as well, because CAP 597 also relates to mainland judgments.
Thank you, Chairman. Now, this interpretation is correct. On Roman numeral 1, 2, 3, now this is about effective judgment. Now, effective judgment, it's a label. In the 2019 arrangement, we had reference to Mainland approach on a judgment being effective. So we use this wording. So the concept of being effective is the way it's used in the Mainland. Now, in the one signed in 06 now, it's not vastly different. At the time, it's used final and conclusive is the terminology used in Hong Kong. But there's no substantial difference. Now, in our exchanges with Law Society, we found ourselves of similar view as Law Society. So there's an annotation of this difference. So when we talk about the law, this law being effective, now there's a certificate. The litigant has to have a certificate issued by the Mainland to show that the judgment is already effective according to Mainland law. And if there's an appeal or there's a second instance trial, now the application is stayed. So this is same as in 319 and Cap 597. There's no difference. Mr. Lei Tong Kok. Now I also asking about effective judgment. The members have already spoken about that. If someone has a judgment certificate issued by Mainland Court and it asks for enforcement in Hong Kong, what does he have to produce to show that he meets the requirement for effective judgment in Clause 8? This is very important because when one applies for enforcement, he has to understand what wording is required by Hong Kong court. Now, if the ruling is in his favor, it may not be enforceable. There may be several circumstances, as in Clause 8. So, what mechanism is there so that when someone wants to enforce a Mainland judgment, he can be sure it's can be done? Now, if he has to engage some counsel, and local solicitors may not be knowledgeable, so he may spend a lot of money and it may not be helpful. Now, we can go into the details in Clause 8, but perhaps please explain briefly. Now, the litigant has to show a certificate issued by Mainland Court. Now, in Clause 13 of the bill, now you have to produce the certificate to show that it's effective according to Mainland law and it would meet the requirement. So we can go into details when we come to Clause 8. Next, Paul Chair. To a certain extent, it's a question by the Law Society. Now, the difference in the two regimes has been explained, but the crux is that one wishes to be able to cope with the two schemes. So Cap 319 and 597, should they be amended at an appropriate time to avoid this interpretation being affected in the future? Also in Cap 639, the matrimonial arrangement cannot be a model because after judgment it can be reopened upon application. Now concerning interpretation, I'd like to ask, of course we exclude all interim judgments, but we know that when litigation is being handled, very often these interim judgments may be very significant. For instance, with regard to injunctions, for instance, prevention of assets being siphoned away. So the interim judgments may not be that stable. Same for Hong Kong's interlocutory injunctions. Now, for the sake of justice and fairness, now to strike a balance, to avoid instability, now since you have mutual recognition, now to prevent assets being spirited away, can you make a bolder decision? Now concerning this bill, we had reference to Cap 639, the blueprint, the overall plan. Now, the Law Society commented that in the wording or in the draft wording or in the plan of the wording layout, it's not that dissimilar to 597. Now that's the Law Society's observation. Now the layout or the wording, now we are not trying to take it verbatim from Cap 597. As for the overall design of 597, the registration mechanism. Now the basic approach is still very similar. So we basically adopt the 597 basic theme. Now, why is the wording more similar to 639 than to 597? I think this is just moving ahead with the times, because 597 was done in 2006. It's rather dated. So in the way we draft, we try to be more modern. Now, 597 may have followed 319, which was even more dated. So in the layout of our wording, we try to be more pragmatic, and so the reader might find there to be some difference, but actually our design or layout is more progressive and more user-friendly than the older versions. So previously mentioned that the title and the contents of the bill are rather technical, so we try to do some work on that. We don't think that we have to stick strictly to the wording of Cap 597. Now, although some legal professionals prefer that, yet we don't think we need to stick blindly to Cap 597 wording. We can jump out of that framework to make it more understandable. Now, the second question is a very good one. We know that for some interim orders, if they can be implemented, it would be good for both sides. So Hong Kong's location as a place for litigation would be enhanced. Now, looking at the 2019 arrangement, Section 28, now there was a hint that something couldn't be done. Now, concerning preservation and provisional help, so we can try to build on that. Now, let me just pursue a little bit further. Now, on the first question, since we shouldn't, it's been said that we shouldn't just copy from the old. 319 has been there a long time. There's a case law already. So can our definition can it be mentioned that even though the term effective judgment is now used, actually is the same, so that the court can note and construe accordingly. So please take note on Clause 2. Anything else? If not, we go on to Clause 3. Clause 3 Mainland judgment on civil and commercial matters. Now, mainland judgment in civil or commercial matters. Now, on the funds for in compensation. Now, this is consistent with 319. It's similar in criminal litigation. Now, in criminal litigation, the court says that there has to a payment has to be made, and this is in accordance with mechanism. And on subclause 2, it says that under subsection 2, it says that if it's as long as this mechanism is complied with, it can be done. Legal advisor, what conditions will determine whether a judgment will be a judgment in civil and commercial matters? Now, in Hong Kong, if it's not criminal, then it's civil. Now, this is very different from the mainland. Now, in mainland there is civil, administrative, and criminal. So in some cases, it may be a criminal litigation. So here we are saying that we have civil part in common. Now in Mainland, the civil litigation doesn't include commercial litigation. So there are certain requirements in the Mainland for that. Now, so civil matters are in 11 categories. So that's similar to the Hong Kong arrangement.
I replied to the legal advisor's letter, and in paragraph 6 of my reply, I explained this point. Simply put, in relation to maritime contract, matrimonial, tortious claim, and other two categories of procedural litigation are included in the Mainland system. Now let me also supplement. At the time of applying for registration, a certificate will need to be submitted. The certificate will prove whether the judgment is of a civil commercial in nature. So the certificate will also provide proof. Any other questions? Please continue. Clause 4. Hong Kong judgments in civil or commercial matters. This is a mirror provision of Clause 3. Clause 4 is drafted very similar to Clause 3, except that we provide that judicial review is not covered, and also the proceedings arising directly out of the exercise of an administrative power also not included. And let me briefly respond to the legal advisor's question. She asked what is meant by proceedings arising directly out of the exercise of an administrative power. Paragraph 8 of our reply to the legal advisor's letter provides certain examples. For example, we use cases brought by the SFC, Securities and Futures Commission, according to the relevant ordinance. That is, when they exercise investigation power or when they initiate certain legal proceedings to revoke licenses, to impose a financial penalty. So legal proceedings arising out of these cases are not criminal in nature, but rather civil in nature, and yet these cases are not covered. In the same vein, the problem is, for these cases in the Mainland, they are of administrative nature. And the CSRC also has a similar power, and when the power is exercised, it is administrative in nature, and that is why these cases are excluded. Ms. Carmen Can. Thank you, Chairman. The focus of Clause 4 is what Hong Kong judgment would be put under the REJ, so the definition would be crucial. For Hong Kong judgments, the judgment should be handed down by the designated courts in Hong Kong, and according to Law Society's submission, the Copyright Tribunal is not included. So can you explain this point when it comes to designated court in Hong Kong? Copyright Tribunal is not related. Can you explain why the Copyright Tribunal is not listed as a specified Hong Kong court? The other point is similar to Mainland judgments, interim relief and injunction orders are excluded judgments. They are not covered by the reciprocal arrangements. And I think the Department of Justice's explanation is that this is pursuant to the stipulation in the agreement. So can you explain what is meant by the injunction order against litigation in Hong Kong? That is right. It does not include rulings made by the Copyright Tribunal. Judgments included in different levels of court are specified in the bill. For the Copyright Tribunal, the judgments are not included because it's regarded as quasi-judicial. So it's akin to a judicial organization. It is set up under the Copyright Ordinance with a limited portfolio. That is, the tribunal deals with disputes arising from copyrights issued by certain stipulated organizations. And so far, the tribunal has only dealt with one case. There hasn't been any search in the caseload, and the tribunal is not a tribunal under the judiciary. Our bill relates to reciprocal enforcement of judgments. So the first point, in response to your question, the Copyright Tribunal is excluded. Anti-lawsuit. This is an order that can be granted by a court in Hong Kong barring a litigant from filing another lawsuit in another jurisdiction. So a court in Hong Kong, depending on the circumstances of the case, can issue such an order, and this is excluded, like the Honourable Member said, to reflect the consensus reached in the agreement. As for the Mainland Court, we see there is a similar mechanism, but the legal basis or the justification for granting such an order in the Mainland is not clear. Different courts, different levels of court at different places in the Mainland may have different practices, and that is why the order is not included in the bill either. I understand the second point. As for the first point, may I ask the Department of Justice to think carefully, because it hasn't set out in detail what is meant by a specified Hong Kong court, but as you explained just now, because the Copyright Tribunal doesn't come under the judiciary, it is rather a quasi-judicial organization, and yet it has the adjudicating power over cases of disputes concerning copyrights, and intellectual property cases include copyright cases. So how should they be dealt with in the future? What about the future of the Copyright Tribunal? If I am a party to a copyright-related lawsuit, can I not go to the Copyright Tribunal instead, because it has far-reaching implications since it is not under this bill? So does it mean that if the case is decided to be of this nature, it should come under the tribunal only? Because the litigant will be caught between the rock and a hard place if he cannot take the case to anywhere outside the copyright tribunal. If we go to the subsection 2 bracket 2 of the section, it provides that the specified courts refers to the Court of Final Appeal, the Court of Appeal, Court of First Instance, District Courts, so on and so forth. So what about cases adjudicated by the Copyright Tribunal? Let me clarify once again that the Copyright Tribunal deals with only a limited scope of cases. That is, it deals with copyrights and licenses issued by a specific organization. In fact, only one case has ever been dealt with by the Copyright Tribunal. And this is the New Way case, the New Way karaoke case. Is a copyright lawsuit. So imagine under the license scheme, the premises can use copyrighted karaoke songs, and there was a dispute. The matter was taken to the Copyright Tribunal. As for other copyright disputes, actually they come under, the majority of them come under other avenues of the judiciary, and these cases are covered by the bill. Next, Mr. Paul Chairman, if I may, I'd like to help the Department of Justice. Now, in my recollection, about 30 years ago, when I first started my practice in the legal profession, I took part in a case, TVB versus Cash. It was a long legal battle. I want to know whether it's regarded as another case of the Copyright Tribunal or just one. The other point is about licensing and rate. The Copyright Tribunal has limited jurisdiction, and there has been only one case or maybe two. Now, my feeling is that this is a big step. It's not one step to the moon, but at least it's a bold step. And that we are having reciprocal arrangements with a non-common law jurisdiction. And over the weekend, I read the civil code of the PRC, and there are so many differences with the Hong Kong legal system. There are many issues to be resolved, but anyway, just for the purpose of exchange and to put it on the record, are you trying to sow the seeds now so that you can harvest in the future? Perhaps I'll go back and check, but New Way is the only case as far as I know, but I can go back and dig up more information. Whether we are planting seeds, well, we keep all options open, and we understand the practitioners in the copyright trade have told us about the situation. Apart from copyright issues, there are also IP issues not included here for various reasons, such as patent. And we can go back and have another look. Perhaps after the bill has been passed and implemented, we can take another step. We do things step by step, just taking one step at a time and the small steps. So we'll go back and see whether we can further discuss with the Mainland. Legal advisor.
冇問題。而家
Any questions from other members? If not, come to next clause. Clause 5. Meaning of excluded judgment. Now, within clause 5, in 6.1a, it mentions excluded matrimonial or family case and excluded intellectual property right case. So clauses 5, 6, and 7 are about excluded areas. And the last time there was an information document to members explaining in detail the reasons for certain matters being excluded. In clause 5 was listed, so matrimonial family case into succession, estate, and intellectual property right, matter relating to marine pollution, and so on. E is about the insolvency, and F is persons that are lacking in capacity, and then and then about arbitration, and H and I about judgments already given, and then J is pursuant to what's excluded in the 2006 arrangement. According to the mental health ordinance, sometimes it's not just about the mental capacity of the person. Now, sometimes if it's about a patient, would that be excluded? Now, if that's a decision by a committee and not a judgment by a court, then it's already excluded in nature, by nature. Anything to add? Call. Other members? DSG, please continue. Clause 6. Supplementary provisions for Section 5.1a, excluded matrimonial or family cases. Now, because the matrimonial arrangement already covers that, and looking at the Hong Kong and Mainland law, there are big differences. So there is no common interface, or there are significant differences, so that the exclusion is mentioned in C. Any questions from members? You might take your time. If no question, please continue. Clause 7, as I mentioned, is about the excluded intellectual property cases. This is about it again reflects the consensus agreement. Now, Ms. Kong. Now on 6C1, 61C1. Now, if it's in-laws, the person's parent or grandparents, so father-in-law or mother-in-law. Now, according to Mainland law, there's an obligation to pay subsistence, and so the relevant judgment is not included. Okay, go back to clause 7. Then we come to clause 8. effective mainland judgments definition. There are two subclauses. Subclause 1, that's subclause 4, subclause 2, that's about which judgments are effective. And A, if it's enforceable in the mainland, that is, it's enforceable in the mainland. And B is about which court made the judgment. For instance, in the Supreme People's Court, and then second instance judgment by High People's Court or Intermediate People's Court, and then first instance judgment by High People's Court, or there may be the case may be already past the appeal period, and then and I can further supplement in the mainland on when a case can be enforced, looking at A, so the conditions have to be met. It must be a second instance judgment, or it may be a first instance judgment but no decision on appeal, or the first instance appeal period is passed but no appeal was made. So this reflects how the mainland looks at enforceability. So we touched upon this earlier. Clause 8, any questions? If not, Ms. Chen. Now, colleague mentioned that for the sake of convenience, the litigant or his or her lawyer for enforcement in the mainland. Now, for instance, in enforcement in Hong Kong, perhaps there is now a practice direction with the judiciary, or would there be would it be available only after the law becomes effective? So because for practice direction would be very important in that case. Concerning the effective judgment, allow me to mention again the certificate, because that's very significant. Now, for the content of the certificate, when it's being employed, now there's a mirror approach in Hong Kong. For a Hong Kong judgment to be enforced in the mainland, we would also issue a certificate. That is, both sides use the certificate to assist in the enforcement. So the courts in both places, concerning the contents and the form of the judgment of the certificate, we hope that there can be more agreement and exchanges. Now, on the judiciary, would have to make a practice direction. This would be up to the judiciary to decide. But I can supplement that when the bill is implemented, there would be a set of rules for practitioners. Now, these rules for practitioners were part of our consultation last year. So we call it the proposed rules. So, what is how is the affirmation to be written, and how is to be submitted, so that the litigant can follow these rules. Now, would there be further need for practice directions, then it would be up to how the judiciary assesses the need. I'd like to ask further. Now, the certificates by courts on both sides, if a certificate is issued in the mainland and is for recognition and taken to the mainland, would it have to be certified on the mainland? No, there's no such a requirement in the mainland. Now, if a litigant doesn't have a legal representative, it just takes the certificate to the mainland, or takes it to Hong Kong. Now, how is the certificate to be verified as correct, as true? Does it have to be certified by mainland court? So, someone takes a Hong Kong certificate to the mainland. How does the mainland authorities confirm that it's valid and true? Now, concerning the use of the certificate in the 2019 arrangement and in the bill, there is no requirement for the certificate to be authenticated. This is similar to the approach in Cap 597. Now, if the litigant disputes the authenticity of the certificate, then the court will examine the facts of the case to see whether the certificate can be accepted as evidence. Now, concerning the use of the certificate, as I said, we see that the courts on both sides in this regard hope to have greater agreement on its use, about the principles of the use of the certificate, so that the courts can enter into the discussion. If there are no questions, please proceed to Clause 9, Effective Hong Kong Judgments. Now, this reflects 2 points. Firstly, it has to be enforceable in Hong Kong, and 2, it is given by a specified Hong Kong court. And specified Hong Kong court is in Clause 2. Ms. Kan? Now, on Clause 10, 1A, why is it that the judge, why is the word was used? The judgment was given on or after the commencement date. Does it refer to judgment given after the bill becomes effective? Now, on the arrangement on clause section 8, the documents necessary for application for enforcement. Now, this is Ms. Kan, you have any question on clause 9? We have not yet come to clause 10. BSG, please reply to Ms. Kan. We're now in part 2 on registration of an application. Now, so the conditions for registration, so it has to be made after this bill becomes effective. So because it's not retroactive, so it's only applicable after the bill becomes effective. On 1B, firstly, the condition is that the litigant has to meet certain obligations, for instance, payment of a sum of money or fail to perform certain act required by the judgment, and so that this non-compliance with the judgment was made 2 years before the application.
The last condition is that the application must be accompanied by the prescribed fee. And to answer members' question, in clause 8 about the materials to be submitted, the rules set out specifically what are needed except the certificate. The certificate can be found in clause 13. Ms. Ken also asked about clause 10(1)(a) Roman 1. It's a drafting point, and I will defer to Selina, our colleague in the drafting division, to take her question. For clause 10(1), the act in question is registration application. So this is the time frame as reference. Now we are making this application at this time, and the judgment has already been made, and that is why we should use the past tense was. I'll see if there is any follow-up question from Ms. Ken. So the reference point is at the time of application for registration, and that is why it's drafted in such a way that the judgment was given and that the past tense was is being used. And you mean that the judgment handed down only after passage of the bill will be included? Yes, the understanding is correct. So regarding the requirements under clause 8, some of these requirements would be included in the rules, not in the bill itself. Because I understand the bill doesn't reflect everything. It doesn't reflect the two scenarios. And also judgment following an ex parte hearing, and that more proof is required, such as serving of notice, it should be proved, or serving of judgment should be proved, and other details. It seems they are not included in the bill. Just by reading the bill, it sounds apparently quite simple. You just need to register the judgment. But there are different scenarios. That depends, for example, whether the judgment has been handed down after a formal trial has taken place. I'd like the Department of Justice to explain, please. This is our layout, indeed. For details relating to the application or the different scenarios, there may be different documents needed to support the application. If the application involves an ex parte hearing judgment, then there may be different requirements in terms of, say, the affirmation, and for these details, they are included in the rules. Same as the personal particulars, personal identity. In fact, Clause 8 provides a detailed requirement for proving one's identity. Right. If there are no further questions, Clause 11. Supplementary provisions for registration applications. This clause, well, we're talking about specifically the differences. For example, One easy to understand example is payment by installment. Say different courts may order payments to be made by installments as part of your obligations, and there may be different sums, so to speak. So for a qualifying sum, if it has been paid, then a registration application can be made. So in other words, we can consider that sum of payment ordered as a standalone item, and if it is enforceable, it can be registered, then it falls under Clause 11. Mr. Rincon? Sorry, I don't know that we have completed Clause 10. I have one suggestion for Clause 10, bracket 1. I think that there is an issue with the two language versions. In the English version, it says judgment creditor can make an application. I understand that the word in Chinese "lak leng" means the judgment. So anyway, the creditor can apply for registering the judgment. And I don't think the Chinese word "lak leng" doesn't apply, because in English it doesn't mean that. Ms. Lau? Please allow her some time to read it through. In Chinese, this clause means that the judgment creditor may apply for registration order for the judgment to be registered. So this is the order to be made. Sometimes we don't match word for word between Chinese and English versions. Sometimes there may be an implied meaning, and there is no need to use another word to explain the expression. And in fact, this is quite often used, this expression. In other words, after registering the order, you need to use a verb. It's not about an order. This is about an order for somebody to apply for registration. Still, I find it strange, because in Chinese, the word 债权人 means a creditor, and then the creditor can apply for. And then in Chinese, it seems that the creditor can make an order. It doesn't seem right. In fact, I see a verb, the verb register, in the Chinese version of the clause. So the creditor can apply for registration and can order that the judgment be registered. And in Chinese, it doesn't read right. Just go back and think about it. I just find the drafting a bit strange. That's Ms. Kong's comment. Go back and think whether you want to make any change here. All right. In fact, we've moved on to Clause 11. Clause 11, any questions? Especially on the word sum. Legal advisor. Perhaps the administration can explain for us about the justification for setting a 2-year time limit. The legal advisor asks us the 2-year statutory time limit, and this is in fact a condition laid down in Clause 10, that is, a default in compliance with the requirement occurred within 2 years before the date of the application. So why 2 years? We consider how a mainland court would consider the validity of a judgment. You may recall when we scrutinized Clause 8, when we considered what is meant by an effective judgment, we mean that it should be effective in the mainland, and or it is enforceable to phrase it in our own jargon, in the mainland is termed effective judgment. In short, it means enforceable. So, as far as the mainland law is concerned, when they consider whether a judgment is enforceable, they have certain conditions. And in Section 246 of the Civil Code of the PRC, they have a time limit for enforcing a mainland judgment, and that is one of 2 years. So, since we require a mainland judgment to be effective before they can be enforced across the border or across the boundary in Hong Kong, we adopt this 2-year time limit as the principle. So this is the policy consideration for Clause 10. As for the relevant principles, we note that in the Hague Convention in relation to the choice of court and other international reciprocal enforcement of judgments, they have also the 2-year rule. Ms. Carmen Can. The legal advisor asked a question and the Department of Justice replied, and in their reply they explained that for the civil procedure law in the mainland, 246, the time limit is 2 years. What is the commencement date? Is the commencement date 2 year the period 2 years from the start of the judgment or the start of the application? According to the bill, it runs from the date on which the application is made. So it doesn't tally because you have 2 years to enforce the judgment. How about I just dawdle and then I don't apply, and it is possible to go beyond 2 years. Hence, we should now go to Clause 12 in order to answer that question. For the 2-year period, it commences on the date on which default occurs. So for Clause 12, it refers to a default situation, and that the 2-year period will run at the start of the default. And it provides here that if it is spelled out in a judgment, it should follow the stipulation in the judgment and count the 2 years. Otherwise, if it's not specified, then we look at 12b, and that it should start on the date when the judgment becomes effective. So this is how we consider and calculate the 2-year time period. Right, let's deal with clauses 11 and 12 in one go. I'll see if members have any questions. Take your time. If there are no questions, Ms. Carmen Can, may I invite the Department of Justice to elaborate on the point, because within 2 years before the date of application in Clause 10, this is about the judgment creditor's application. So 2 years before, right? Within 2 years. Within 2 years before the date. So 2 years before the application, does it mean it is still within 2 years of when the judgment becomes effective? What can you clarify the mainland judgment? Is there any requirement for the mainland judgment to be enforced within 2 years after it's been handed down, or else it will not be effective? Does it directly relate to the point of default, or Does it mean that it should be enforced 2 years after default occurs, or 2 years enforced 2 years after the judgment has been handed down? The Civil Procedure Code 246 provides the 2-year limit, and the 2-year limit is by and large consistent with the Hong Kong system. It provides that it should run starting from the last day of the judgment, and if there is phased implementation of the judgment, then it should count as since the last date when it is effective. If it is not specified, then it should be the date on which the last date on which a judgment becomes effective. So responding to members' question, for point B Roman 2, that is, a default in compliance with the requirement occurred within 2 years before the date of the application. So this is about the default.
Perhaps the DOJ can supply the scenario in her answer. It can be in writing. If you, the wording here, now you can say which date the obligation has to be met and the creditor didn't comply. So when the application is made, how is the default counted? So the public can understand about the clauses 11 and 12. Mr. Ring Kwong? I have a similar question. Now, in clause 12, you refer to 11.3 and 11.4a. Now, clause 12 is to explain the date on which a default is made. However, 11.3 and 11.4a, the default date does not appear. The dates on which a default is made is not mentioned, so clause 12 does not connect. So the DSG, please explain to us the relationship. So we already been talking about clause 12. Any more questions about clause 12? Of course, after the meeting, there will be a written explanation. DSG, clause 13, please. It's about the court of first instance, the registration order. That is, if conditions of clause 10 and 11 are made, then a registration order has to be made. It mentions the use of the certificate because one of the conditions, you might remember, is that the judgment has to be effective on the mainland and has to be in respect of civil and commercial matters. So the Hong Kong court can then refer to the certificate issued by the court on the mainland to show that the judgment is an effective judgment on the mainland and is about civil and commercial matters. Now, this certificate is to be effective accordingly. Now, subclause 3, now after the registration order is made, then the litigant has to deliver the the registration order to all the parties affected. Now, 13 or 13.1, Now you say that as long as it meets, is in accordance with clauses 10 and 11. Now this is new law, so it's safe to say that it's in compliance with subsection 10 and 11. Now, would 10 and 11 be sufficient for protection? The conditions is that clause 10 says it has to be it's committed after the bill becomes effective, and it's has to be an effective judgment on the mainland. And it's embedded in the judgment, the mainland judgment, how it's made. So it's already done in clauses 10 and 12. So in part 1 of the bill, we made a good podium. We had laid out the definitions and interpretations. So we make use of the interpretations in part 1, and then when we come to part 2, we use clauses 10 and 11 for a simpler mode of drafting. Now, I'm just suggesting a broader safety net. I just thought that clauses 10 and 11 are not sufficient. Mr. Lam San Keong, Vice Chairman, 13.1 in English. It says that it's in compliance with sections 10 and 11. Now, maybe shall order, and it doesn't have to be may. We want to give the court some leeway. May order to be registered. Because when I read the Chinese, as long as you meet the clauses, sections 10 and 11, then you can have an order to be registered. Now, but in English, the word may leaves some room. Ms. Doreen Kwong, on 3B in 13. Now, the applicant must serve a notice of registration on all persons so far as known to the applicant. Now this means that the judgment debtor has to meet certain obligations according to the court. Pay the, for instance, payment according to the judgment, to pay what you need to pay. So in English, so far as is known to the applicant. Now this is understandable. The applicant So it's only to those known to him, so that's reasonable, and against whom the judgment or part may be enforced. Now, this information is that available to the judgment debtor because he is the person concerned, and the judgment debtor, if it's a natural person, now he may be deceased. Now, if it's known that the debt can be enforced by his successor, then it can be served to that successor. Or for some commercial organizations, they can sell the obligation, the debt obligation. So if that's known to the applicant, he can serve that to them too. Now this is rather unclear. Now this is very broad. There is no standard. Perhaps the DOJ can reply in writing how to improve this. DSG, anything to improve? No. So perhaps you can address that in writing. Ms. Maggie Chen, I'd like also to follow up on clause 13.3. B, serve. Now, when would be a service be effective? If service involves is served within HKSAR, or it can be a mainland jurisdiction. So, of course, service must be effective, otherwise it's not meaningful. Now, what would constitute effective service? Now, serving would be according to existing rules. So this is not further explained in this bill because that's not necessary in our policy, because service in current legal procedures is already stipulated. Now, the only thing we can add is that serving the registration notice, if it's out of jurisdiction, then one doesn't have to apply to court for additional permit. So this is consistent with similar mechanisms we have. So this saves resources for that person. So who doesn't have to spend more resources on delivering on service out of jurisdiction. Next, Carmen Can. Now on 13.1, apply to which court? In English is court, capital C. Now, in Hong Kong, there's only the CFI. It's very clear. Now, in the Chinese version, in interpretation, there's no further definition of court.
Means because in English, in court means in the court of first instance, but in the Chinese version, I don't see any additional definition. Is it because in the Chinese version you've put down 原訟法庭 court the first instance? In English it just says the court, it doesn't tally. Right, we'll go back and think about it because in Chinese it may not be clear just to use the word
then when the court does the registration, then it treats as Clause 19, any problem? Please continue. Then then Division 3, setting aside registration. Clause 20, applications for setting aside registration. A person against whom a registered judgment may be enforced may, within the period specified, which will be referred to in Clause 21, and then it can apply to the court to set aside the registration. And Clause 21 says that there's a time limit for setting aside registration. The purpose of subclause 21 is that if now after the registration, the person has to serve the notice to persons for whom that is enforceable, and then within this time period, the 14-day there's a 14-day period for application to set aside the registration, and this 14-day period can be extended. So clauses 20 and 21, any question? Please continue. Clause 22, setting aside registration. The grounds for the setting aside. Now, the application is according to Clause 20, and Clause 21 is about when it can be made, and then Clause 22 are the grounds, it's about grounds for setting aside registration. Now this is about Clause 12, Section 12, one of the arrangement. Now if the application has proved that a provision has not been complied with, and then this reference to Clause 23, so B, one reason is that the jurisdictional requirement is not satisfied, and so you can refer that to Clause 23. And for C to K, this reflects the Section 12 of the arrangement. So the C, the defendant was not summoned to appear in the original court, or he was summoned but he didn't get the opportunity to make a statement. So that's a procedural injustice. Now, D is that the judgment was obtained by fraud, and then E, the original proceedings for the registered judgment were accepted by a court in the mainland after procedures in respect of the same cause of action started by a court in Hong Kong. So, and then F, a court in Hong Kong has given a judgment on the same cause of action between the same parties. So that's about. So that's a principle mentioned in the document on public policy. In Lin G, a court in a place outside Hong Kong has given a judgment on the same course of action between the same parties, and the judgment has already been recognized or enforced by a court in Hong Kong. So we have already recognized the court in that place. So there's no second trial principle. And then an arbitral tribunal has made an arbitral award. Now and then an arbitral tribunal has made an arbitral award in some other place, and it has and the award has already been recognized by a court in Hong Kong. And then the enforcement would be manifestly against the public policy. And then K, this goes back to the fact that the registered judgment has been reversed, otherwise set aside pursuant to an appeal of a retrial. So in that case, the registration of Hong Kong can be set aside. So these are the various cases mentioned in 22(1). And then 22(2) says that the court may the court may set aside the registration. It has the discretion, and if the applicant provides proof that the application is against an arbitration agreement already made it's a valid arbitration agreement. And then subclause 3, it's to avoid doubt. Now, we mentioned that in our response to legal advisor. Now, a preliminary issue doesn't affect whether the registration is set aside. For instance, first you have to decide whether a patent is valid before you decide whether there would be damage. So this states very clear that the preliminary issue is not a ground for setting aside registration. This is to avoid doubt. So I declare that the meeting is ended for 15 minutes. We will conclude the meeting after this item.
Bracket 4, in the event of the registration being set aside, then the registration ceases to be effective. Ms. Carmen Can. Thank you, Chair. I'd like to go back to clause 21. We were going a bit too fast, and I have a question on the 14-day period. For 21(1), the court may, when making a registration order, specify a period within which an application for setting aside the registration may be made by a person. So if the date is not specified, then the default is 14 days. on the premise that the notice has been served. Now, if the other side of the suggests that no notice has been served, will the court specify a date that is shorter than the 14-day period? So without any specified period, it will be 14 days. What is the policy consideration? Does the 14-day period stem from the agreement, or whether this is modeled on Cap 319 or Cap 597? The next question is Clause 22, bracket 1. The court must set aside the registration, and then it sets out the grounds on which the registration is to be set aside. Is it an exhaustive list? It runs from A to K, and in fact for 23 bracket 2 and 22 bracket 2, that is if the applicant is able to raise another ground on which the court is satisfied, then the agreement can be set aside. So 1 and 2 is about setting aside registration, and then 2, if the applicant has proved to the satisfaction of the court. Right, no. Bracket 2 is supposed to require proof that it runs contrary to a valid arbitration agreement or a valid jurisdiction agreement, that is an agreement entered into by parties in another jurisdiction. So the scope of application is quite narrow. Are you trying to come up with an exhaustive list under the circumstances, the circumstances under which the court may set aside registration? For 21 bracket 1, the 14-day period, indeed this is modeled on the existing practice, and we consulted the judiciary. The current practice is also one of 14 days. In terms of drafting, we can go back and see whether we can make it more clear. In English, we say it's by default 14 days, but the court has the power to extend the period beyond 14 days. Perhaps this will provide more clarity, right? Because apparently this suggests that it may be shorter than 14 days. Yes, perhaps we can make a change here. And about Clause 22, setting aside registration. Thank you for raising this issue for me to further elaborate on this point. Clause 22 provides an exhaustive list of reasons for setting aside the registration. By exhaustive, we mean there is no other ground on which the registration can be set aside. This also reflects the 2019 agreement. For 22 bracket 1, is a mandatory requirement. That is a mandatory ground on which registration must be set aside. For 22b, the court may set aside the registration by discretion. So the registration can be set aside by the court's at the court's discretion, and that is the difference. Clause 22 bracket 2, there is only one ground on which the court may exercise discretion to set aside the registration, and that is if the Mainland court judgment is contrary to two things. First, is contrary to the arbitration agreement entered into by the applicant, because if an arbitration agreement has been signed, how come there is a judgment at the end? Because if you've chosen arbitration, there shouldn't be any judgment. The other thing is a valid jurisdiction agreement. That is, they may have opted for a third jurisdiction for arbitration, and because of a dispute, in the end there is judgment handed down by the Mainland court. So under these circumstances, the court in Hong Kong may set aside the registration. So please enlighten me, DOJ. For 22(1) is an exhaustive list, and it's important because an applicant wishing to set aside the registration, you can refer to the grounds A to K, and if it doesn't fall under A to K, that means the court has no discretion to grant this decision. For 22(2), if both parties have agreed to go by arbitration, and if then a judgment is obtained by one party, then the court should set aside the registration of this judgment because the party did not respect the arbitration agreement. The third scenario is something like Cap 639. That is, they originally agreed to use one jurisdiction, and then the judgment is handed down by the court in another jurisdiction. So isn't it a mandatory ground for setting aside the registration? When we discussed the arrangement with the Mainland counterpart, we both had our own considerations. They are reflected in Clause 13. So again, this is one difference between the two legal systems. For the arbitration agreement and jurisdiction agreement entered into by the applicant, how does the court determine whether the agreements in question are valid? For the two legal systems, they have even major differences in the basic legal principles to be applied. And that is why we propose that discretion can be exercised to set aside or refuse registration of the judgment. Because the substantive law in the Mainland is such that the law should not be changed because we have this arrangement in place. As for validity of the agreement, it also goes by our own legal principles. So against this backdrop, a judgment that is contrary to either the arbitration agreement or the jurisdiction agreement should not be allowed to be registered. Right, first of all, we know that this is an exhaustive list. You must be able to meet the ground set out before it can be set aside. Second, on validity of the arbitration agreement and jurisdiction agreement, because these two legal systems have different principles, we allow discretion. Now, how do you prevent a litigant from having a second bite of the cherry to start the case again using this mechanism? Is it that since you have an exhaustive list in bracket 1, if you can't find the ground that suits you in bracket 1A to K, you cannot rely on this to claim merits of the case and retry your case? How do you prevent the litigant from using this setting aside mechanism to have another go of the lawsuit? That is why we have an exhaustive list, and if you can't find the appropriate ground, you cannot set aside the registration. This is the outcome we want to achieve. The other point is under the mechanism of reciprocal enforcement, be it Cap 597, 319, or Cap 639 or other mutual recognition and enforcement mechanism under the common law legal system, we adopt the same principle. In other words, the court will not reopen a case based on the merits of the case as claimed by the litigant. That is, we are not going to reopen the case to determine the obligations and the rights of an applicant. This also applies to the enforcement of an arbitration agreement. Say if it is just like receiving an arbitration agreement from Macau or from another place, we're not going to consider again the dispute itself. We only consider whether there are grounds to set aside the registration. So we are confident that we can make use of 22(3) instead of including this phrase to avoid doubt, and that through this provision we can make sure that the applicant will not further cause delay to the legal proceedings on the basis of this setting aside mechanism. Prima facie, we believe it is sufficient, and we believe that it reflects a policy intent, and at the moment we don't think it is necessary to add the part as suggested. Right, I think we should end here. We're at clause 22. Next time we'll resume clause by clause at clause 23. I will decide the next meeting date after the meeting, and then the Secretariat will issue a meeting notice to you. Let's see if you agree with the arrangement. If there's no objection, the meeting's adjourned today. Thank you.